public transportation is so important.
So happy. So Wendy, it's rail day and there's a drinks on the train from.
There's an event. I don't know what will be served because it's not my event, but
Oh,
I believe it is refreshments.
It is refreshment.
It's refreshments and shrimp.
And then we learn, okay, great.
I mean,
But then we learn about the freight and the passenger rail and hopefully learn about future improvements.
It's great. It's a day we all look forward to. It's like stepping back in time because the train is outfitted for like 1950. So we should all be, in our madman outfits
That's
for
funny.
going on.
When
Anyway, what?
when are we doing this?
I think it's at 4:30 on.
I think
So
so.
it's before.
Some of this will be in committee.
Yeah. So, yes.
You can come after.
So
Some of this will be in
we're sorry, we're a little late. We're in Senate Economic Development. It is the 20th of April. That would have been my mother's 98th birthday. It's a start, we think of,
Queen Elizabeth died on my mother's 100th birthday.
oh, wow, that is significant. And we are here switching from workforce development to labor issues, to workforce, to workers' compensation and to unemployment insurance. And with us, we have had some discussions about this. There are 3 bills that are represented now in the draft that we have before us, which Damien will go through with us and update us on and bring us back up to speed. And our last conversation had us agreeing to putting those elements in together. And we're just going to go through what they imply, and we're going to hear from the interested parties and stakeholders, all of whom seem to have gathered. Well, maybe not all of them, but most of them. So, Damien, it is yours. Take us away.
Great, thank you. For the record, Damien Leonard, Office of Legislative Counsel. So if we're looking at the draft 1.1.
And you should have it on your desks, I think. Scott's gotten it to everybody.
Okay, so we're looking at draft 1.1, which is a strike all amendment to H217. The first few sections are from the H217 as it came over from the House. Section 1 just sets the workers' compensation administrative contribution rate for the coming year. It keeps it at 1.5%, which is the same as last year. This is a rate we set every year. And so this would be the rate setting for this year.
Which is the same as last.
Yeah, keeps it exactly the same as last year. Section 2 is really, it's a backstop, or it creates a backstop. We've had a couple instances in recent years.
That's right.
Where the workers' compensation contribution rate was in a bill that was touch and go on the closing days of the session, and it wasn't clear if it was going to pass, and that would have created problems for the workers' compensation program. So this would just add language providing that if for some reason the General Assembly did not pass the rate, it would just remain unchanged from the prior year. So
as I recall, it was when we had a challenge about this was when it was in a bill that was vetoed. That right, and then the rate was in that right. Anyway, it doesn't matter.
There have been a couple of different.
It's that kind of a scenario that's where you can't afford to have the rate compromised.
Right. It's often put into a bill that has other provisions, and it's been the other provisions that create controversy.
Right.
So anyway, this would just allow for the rate to default. And most years it doesn't change more than 1/10%. So having it default to the prior year's rate would not have dramatic effect, apart from allowing the program to continue operating. Which is so section 3, this is language making permanent what had been a trial program that is set to sunset this July 1. So this is what it allows is an individual who's been receiving workers' comp benefits, and the workers' comp insurer provides notice that they're going to discontinue the benefits, it provides the ability for the individual to seek a 14-day extension if they want to contest the discontinuance,
Right.
so that they can gather evidence of why they think the benefit should continue.
It was a pretty long trial too. It was
It
8-year
was.
trial, so it's not like this
Oh,
was
wow.
just, this was a fairly substantial.
Yeah, this
trial.
is, I think we added this language during my first biennium with the legislature.
14, your first biennium?
Oh, I started in July of 14, so this would have been my predecessor. There you go.
There we have it.
So, anyway, so this would make that permanent. And going on to page 4, we start the new language, which is from S101, which the committee has had a walkthrough of. But this would be entirely new language getting sent over to the House. So the first section, section 4, this relates to requests for pre-authorization of workers' compensation benefits. And it would define benefits to include medical treatment and surgical, medical, and nursing services and supplies, including prescription drugs and durable medical equipment. So it allows pre-authorization of the expenses of things like a wheelchair, a walker, that sort
A
of thing.
ventilator. I mean, some basic devices that are needed
Right.
for medical treatment.
And it's, so what you'll see throughout the section is we've struck medical treatment and replaced it with benefits. And otherwise, a lot of it is cleanup apart from that change. And also specifying that the request for pre-authorization has to be in writing. And then some more clarification about notice back from the insurer on their decision, clarifying that the benefits can be denied if they're unrelated to the work injury. And then a lot of just housekeeping changes throughout the
Right.
section.
The big thing is just including devices.
Yeah. In section 5, this would add an entirely new section to the workers' comp law regarding when a work search can be required and when it cannot be required. So it allows an employer or the employer's insurer to require an employee who's receiving temporary disability benefits to engage in a work search if they're medically released to return to work, either with or without limitations. The employer has provided the written notice to the employee of that medical release with the list of any applicable limitations, and the employer doesn't have a job available for the employee that the employee is medically released to do. So for example, an individual is released to do light work, but they can't do the lifting necessary for their normal job. The employer only has jobs available that require that heavy lifting. So then the employee would be required to do a work search elsewhere, or could be required to do a work search elsewhere. And then in subsection B on page 7, it specifies that we would not require, or we would not allow work searches to be required if an employee is either already employed or has been referred for or is scheduled to undergo one or more surgical procedures. So 2 instances when they're either already working or when the work search would likely be futile because they would be undergoing surgery. And then limiting the work searches to 3 employer contacts per week, which is the same number we require for unemployment insurance.
That's in C. Right?
That's in C.
So that's the same as UI. That's
Yep, that's the same as what's required under UI. In
okay.
Section
Section
6, this relates to temporary partial disability benefits. So remember, we have partial disability where you might be able to do some work, total disability where you're completely out of work, and then temporary benefits, which can run for a very long time, but there is an endpoint at some point there, and permanent benefits, meaning you've reached your medical endpoint and you're not going to get any better. So this is temporary partial disability benefits. So
So there are how many different classifications? There's partial, temporary partial,
there's
temporary.
temporary
permanent?
partial, temporary total, permanent partial, permanent total. 4 classifications.
Okay,
You know,
Do you know how many people are out on permanent? Is that
uh,
data available?
must be. Dirk must have that.
General.
Just identify yourself.
Oh, I'm sorry.
That's right.
For the record, Dirk Anderson, Director of Workers' Compensation, Department of Labor. Kelly can correct me if I'm wrong here, but any permanency benefit requires a submission by the parties to the department, which the department would have to approve. So I could probably run a report that would show, on an annual basis, how many people were awarded a permanency benefit. I don't have that number off the top of my head.
And I wouldn't expect you to have
It
it,
would
and I
be-
didn't mean to say that, but I'm just curious to know how many are, the annual would be interesting to know too, but I was thinking just the total amount.
I think if we could get both of those, that would be very useful, I think, just to give us a picture of the number of people we're talking about.
Okay,
In each of these,
in terms of partial benefits, I think we did get some anecdotal numbers, like annually, there's something like 2,000 people receiving temporary total disability benefits for some period of time. And
so how many did you say?
2,000.
2,000 receiving temporary total disability benefits for some period of time in that year. We estimate that temporary partial disability benefits are awarded at maybe a 20 or 30% rate compared to temp total. So let's say, again, these are very rough numbers, but in any given year, you may have 500, 600 people on partial disability. And the permanency numbers, I don't know. I can get you
So if you
those.
could get us some numbers, I think that would be helpful as we go to some of this on the floor.
And bear in mind that that permanency benefits, a permanency rating can be anything from 1% to 100%. So you can be permanently disabled for a relatively, like if there's something you're never going to be able to do again, it's like maybe raising your arm above your shoulder, you might get a 6% rating. Doesn't mean that you can't work.
You could work in some other capacity.
Yes, but it does recognize that your ability to work has been diminished and there is a dollar amount associated with that.
And you're compensated for that percent of the work, of a type of work you can't do it.
Correct.
Got it. That's interesting. I hadn't understood that aspect of it before. I think we all maybe thought of it as like, oh, you can't work at all, but of course you could still do something using other desk work.
Retrained.
Yeah, and having just done the workforce development bill, if we have retrained and upskilled you. Okay, Damien, sorry. keep
that's
going.
fine. That's fine.
Helpful to, so it's temporary partial, temporary total, permanent, and what's the fourth one? Just partial?
No, so think of it as a grid. Partial, total along the top, temporary, permanent along the side. So you have temporary partial, permanent partial, temporary total, permanent total. So you fit into one of those 4 boxes.
Got it. Thank you. Good to understand those boxes. Okay, so finishing section 6. Because this has a lot in it.
Yes, so
Section
this, starting on the substantive changes really start on
Page 8.
page 8. So the first of them is how we calculate the temporary benefit. So we're talking about temporary partial benefits. So the individual is earning some money from work at this point. And so what this would basically provide is that your benefit is the difference between the wage that you're earning and the amount that you would be eligible to receive if you were totally disabled. And then that would include any applicable cost of living adjustment or dependency benefit due. And then there's also additional language if you're receiving the maximum weekly compensation. 2/3 of the difference between your partial benefit is 2/3 of the difference between your average weekly wage before the injury and the amount that you earn during the period of disability.
So this is all how we calculate it.
Yeah,
What if you are earning more than you were in the job in which you were injured? If I'm partially disabled, so I can't work for the construction company right now because my leg was broken and is healing, but I get a job working on computers
it pays more.
that pays more.
I don't think you receive benefits at that point.
Kelly has the answer.
Yes, Kelly Massacott, that's correct. You wouldn't receive
Zip.
any temporary benefits.
Right.
The permanency benefits, you actually might be entitled to the permanent partial, but in terms of wage replacement, you wouldn't receive any wage replacement.
And is the state notified of that when that happens? Or how does the employee have to let the state know?
Oh, the employee has an obligation to let the workers' comp carrier know so that they're not issuing benefits to them. Absolutely.
Yeah, so important thing to keep in mind here is this is primarily private insurers and the employees. The state gets involved when there are disputes or when there's permanency. So the state regulates the system. But the primary action happens between the workers' comp insurers, the employers, and the employees.
Okay.
So
Unlike
did I describe that
unemployment.
correctly?
I think that's accurate.
Okay, so I have the luxury today of being surrounded by people who are
Yeah,
far more
the
knowledgeable
experts.
about this than I am.
No, we're
So
lucky to have
if
them.
you see me
we-
turning behind me
yeah.
for approval,
Which is great. It's wonderful to have you all in the room.
it's a complicated system and we're lucky to have some people with us who understand it very
No, I
well.
just did my simple grid on the back, so I can view it.
Yeah, well, so if I give you something like a simple grid, that's because that's what I use to try to remember where things fit.
So the
How
first
it
part
is there.
so A includes how we calculate this temporary partial benefit.
Right, and
And-
so A and B are, A1 is calculating the benefit. A2 is the annual adjustment to the benefit. So starting on line 12 of page 8, this provides that compensation would be adjusted following the receipt of 26 weeks of benefits and then annually on each subsequent July 1st. So if you get injured on June 15th, or your period of disability starts then, you don't get an adjustment 2 weeks later on July 1. You have to go through 26 weeks of temporary benefits, and then you'll start cost of living adjustments. Does that make sense?
And
Great.
another thing that would be useful just to have, and I may have this in my notes that I just don't know, is what are the average time periods that people are out on these different benefits, on these different worker comp.
Yeah, I certainly don't have that information. I have to,
And maybe Kelly has provided that. Do we have, does the department have any of that?
I have not provided that. I could,
I mean, it would just be, any statistics on workers' comp would be useful.
sure. I mean, it really depends on the injury.
Right.
Break your leg,
No, no.
you're out for 6 weeks, you need back surgery.
But for those of us who don't live in this world, it just would be useful to have a picture of it. So, sorry, maybe that's just, so, sorry, maybe I didn't mean to interrupt.
okay, so subsection B, starting on line 17, this would provide a dependency benefit of $20 per week for each dependent child under 21 years of age, provided that no other injured worker is receiving the same benefits on behalf of the dependent child or children. So you have two parents, you can't double dip on the dependency benefit. So if you have the unfortunate reality of both parents being injured at work, so it's just and then the amount for dependent children is adjusted weekly to reflect the number of dependent children. So it reflects that kids grow older. or that maybe your family status changes and you no longer claim them as dependent because they're now dependent of another parent. So,
And it takes the amount up.
Or down.
or down, it adjusts each week depending on the number of children. So think it's $20 times the number of children. So say my child is 20 years and 11 months old when I get injured. For 1 month, I'll claim that $20 dependency benefit. And then after that, they're over the age of 21. And so I can no longer claim that benefit.
But the amount had been 10, right? So here is the first instance of taking it back to 20.
So this,
I just want to,
yeah,
isn't
so
that correct?
this is a $20 dependency benefit here. And the dependency benefits prior to this were $10.
and that was set in 1959 or something.
I don't know the exact day it was set.
1981.
Oh, 1981.
1959 was the date, was the year that the dependency benefit originated. At that time, it was $2.
Wow. So
At that time, if you made $10,000 a year, you were doing well.
got it. So 59 and in 81, it went up to 10. Okay, that's helpful.
Just a question, just about this process. Does the administrative time to make that adjustment weekly, is that justified by the amount, you know, the likelihood that it's going to change? It just, I'm just thinking about the paperwork and being if the employer is part of this, it could just be a pain, right?
I can't speak to that. You'd have to ask the other witnesses. So,
Do you understand the question? I mean, if it doesn't change.
Is it the
that
employer or
much,
the insurance company that pays it?
that
It's the
pays
insurance
it,
company.
Right.
It's not the employer. It's not a burden on.
But if the employer has to sign off on the paperwork,
No.
It's generally the insurance company.
It's the
is
insurance.
adjuster who is doing this on a weekly basis.
so they'll call the person. All right, if you all
I just
are
know
all
it's
fine with
appropriate
it, that's
to speak.
fine.
I'm sorry, I just don't know what.
I'm happy to acknowledge it, Kelly.
Thank you. In terms of dependency benefits, there's a Form 10 that gets filled out at the beginning of the case that lists the birthday, and that goes to the adjuster. And then if there's any change to that, obviously they have the birthday, they know when the person turns 21 and they stop the benefit. But if I have a client with a baby that's born, I then send them a new Form 10, excuse me, I said Form 10, and it explain, hey, the dependency benefit is now due because my client had a baby. So it's a one-time form in most cases that goes to the adjuster, and it's only updated as needed if somebody has a child.
Okay, so this says it'll be adjusted weekly. So I'm just concerned that there would be extra paperwork.
That's just the baby's born in the last week, now you pay the extra $10 because I've updated the form, but it's pretty rare that the form actually gets updated or the amount has to get adjusted. It's either the child turning 21 or a baby being born that would require an adjustment.
Oh, all right, so it
No
doesn't need to be
obligation
adjusted
report on a
weekly.
weekly basis, how many dependents you have. There is none, right? You just.
Okay,
says
so maybe we
weekly, but-
should,
It's status quo
Yeah.
until there's a reason.
Until there's a change.
all right,
Then why does it say adjusted weekly?
It's replicating the same language that's for the dependency
okay.
benefit in the TTD section,
Okay.
temporary 12
Fine. Anything else on this section? So we've taken it up, and anything else in this section? Yes.
So, yep. So hold on, let me get caught back up.
Sorry, we were on B1.
Yep, so that's the dependency benefit. Under C1A, this relates to timing. So we're on page
Yeah.
9, line 3. So if you're continuing to work for your employer, so in other words, you're partially employed by your employer, payment of your workers' compensation would be mailed or deposited within not more than 7 days after wages are paid. And then the employer would be responsible for providing wage information to the insurance carrier. And then under number 2, if you're working for a different employer, payment of compensation would be mailed or deposited. Right now it says within not more than 3 days after the insurance carrier receives the wage information from the injured employee. So this is date when the wage information arrives. And so right now it would set that at 3 days after that wage information arrives.
Is that comparable to other timeframes?
I would let the other witnesses speak to that.
Okay.
So I think it's a little bit different because you're not calculating the weight based on weekly wage amounts for total disability because you're not earning wages. So this is different from those. So I think it's more a question of, is that a workable, reasonable time
And
frame?
it seems to have been when we first went through this. I don't recall the days.
I can't speak to the.
Right. So we'll come to that. So section 7.
Section 7, we're getting to temporary total disability. So now you can't work. And the changes start on page 10. And so the first major change is on line 5 of page 10. Compensation is adjusted on the first July 1 following the receipt of 26 weeks of benefits and annually on each July 1. So you have to go through 26 weeks of benefits, and then the next July 1 after 26 weeks of benefits, you get a cost of living adjustment. And then each subsequent July 1 after that.
Well, that goes to my question of how long do people stay on workers on disability, and some people for whom it's permanent, obviously that's a lifetime or a lifetime of work. Does it end when you start receiving Social Security? Yes, Kelly?
In a permanent
game
total
show.
disability claim, no, it actually pays until you die. Most of those cases actually do resolve on a settlement basis, but in theory, a permanent total disability claimant could receive weekly payments until they die.
Wow, on top of,
Well, is Social Security isn't paid out of those? You're getting a payment. I'm assuming FICA isn't taken out of that?
That's correct.
Yeah.
Okay, so you would only have the Social Security that you earned up until the time you were disabled, so that makes sense.
right,
Correct.
Right.
thank you for
Yeah.
that.
Workers' compensation is not subject to payroll taxes, and it's also not subject to income tax, right?
Correct.
Yeah. So,
Okay,
yeah, we talked about this a little bit in the context of the paid leave bills, where we've talked about it in past years, and in the House this year, there's some really funky taxation that happens when you have a paid family and medical leave, because the IRS looks at it, is it in the nature of a workers' compensation type leave? So is it for disability that's not covered by workers' compensation? Or is it like unemployment insurance, you're out of work because you're caring for someone else? And so they look at that and then tax your benefits accordingly. So it gets complicated there.
broke
But
my
in this
leg
case-
skiing, so I can't work.
Right, so a lot of this goes back to, let's not go there.
Yeah.
Okay, let's
Let's just stay on this because you've got 5 witnesses here.
here.
Yeah,
we have lots of people.
yep, I saw the weeds looming and
No, it's
Okay.
just for those of us who don't live in your world. Sorry to take you to the weeds. We don't mean to take you down those rabbit
Yeah.
holes, but we're just trying to boot
Good
up.
to know.
Yeah, good.
so, anyway, so and then on line 10 of page 10, we get the dependency benefit, and you can see here that it's increased from $10 a week to $20 a week. And then the amount adjusted again is adjusted every week. And then there's a 90% benefit piece in here. So this is for people. So there's a minimum weekly benefit and a maximum weekly benefit. The minimum weekly benefit is 50% of the state average weekly wage. The maximum is 150%. But there is this catch where if your weekly wages were below 50% of the state average weekly wage, you're capped at 90% of your average weekly wage prior to applying the cost of living adjustment. So essentially, so you don't earn more money on workers' comp than you earned in your job before. And 90% reflects, it's a rounded down from what you would have taken out in FICA.
Maybe we may need a little chart on that.
Yeah, so,
Got it.
I'm trying to visualize.
right.
No, that's, we're
So
gonna get some help visualizing. this
if we
maybe.
think state average weekly wage about $1,000, if you earned below $500 a week prior to getting injured, and you're on temporary total disability, you'll get 90% of what you earned prior to
Got
getting
it. So the
injured.
lower your income, the higher your,
No.
Yeah.
If you're below the minimum benefit,
yeah,
then what happens is you get adjusted to 90% of what you made beforehand instead of getting the minimum benefit. Because we're not paying people more money to be out on disability. So, did I phrase that right?
Yeah.
Good.
I think it's
Just making
also-
sure.
I think
Okay,
it's
got
also about not letting a dependency benefit exceed what somebody had been earning before they were injured. I think that's really what it's about. Like if somebody happened to have 6 kids, you're not gonna go above that, your pre-injury wages
Right.
with the dependency benefit included.
Yeah, so it creates a cap.
good.
Um,
Yeah. well,
so
that's
that
fair. That's-
people don't. Obviously, no one wants to get injured at work, but we're also not creating some sort of perverse incentive.
Yeah, you don't want a perverse incentive. That would be bad.
So that sounds wrong to say, so I apologize if that came out.
No, but I think
wrong,
that-
it
I think-
creates an,
It's understandable.
yeah,
And I think the simple sentence of we don't want to pay people more than pre-injury wages also is simple and straightforward. Okay.
so. Okay, so that brings us to section 8. This is how your wages calculated. So,
Your disability.
yep, so this is all, so this is basically how they calculate your benefits for everything in section 650. So this is, they look at your average wage and they calculate your payments based off of your average wage prior to the injury. And then they, D1 here provides that it's adjusted annually on July 1. And then D2 provides that for temporary benefits, you have to receive 26 weeks of benefits before it's adjusted. So if
Right,
you,
which is sort of what was in the
Yeah.
previous.
right, so this is the reason we've added that to the previous sections is because this was tucked away in a separate section. And so it wasn't entirely clear when you looked at the other sections. And so think of it as belts and suspenders again. We've got the statute clarifying itself in 2 places so that you don't have to look to a separate section to figure out what the benefits are. But here, because it does say it's adjusted every July 1, we're clarifying that, keeping it clear that for temporary benefits, you have to have 26 weeks of benefits before you get that COLA.
Got
And then on page 12, we're clarifying again that for permanent benefits, you don't have to have 26 weeks of benefits to get the COLA on July 1. So, and then in E1, this is, so starting on line 4 of page 12, if you look on line 6, we're increasing the penalty for benefits that are paid more than 21 days late from 10% of the overdue amount to 25%. So that would be an increase in the penalty amount. And in,
Which is paid by the insurer.
yes, so it's paid by the
So-
insured.
So
to
this
the
is, these are big
employee.
companies who ought to be able to get these things
I
out?
can't speak to
Yeah,
that.
okay, generally. So I mean,
So
it's not like this is I'm just to go to Wendy's concern, this is not a burden on the employer. This is a new penalty, an increased penalty on the insured.
Right, so,
I just
this
wanted
workers'
to-
compensation insurer here, and you do have different structures for insurance. So you may self-insure and then have a third-party administrator. But again, this is a 25% penalty if the benefits are overdue instead of the current 10% penalty. And I leave it to the advocates here to discuss the
Got it.
pros and cons
Right.
of this
No,
change.
I understand there are some. So, right,
So that, moving to page 13, we get to the next substantive change.
but wait, can I just also just, again, newbie on some of this, 21 days is 3 weeks. So most of us are paid, at least we are, and in other things, or most of us are paid in 2-week cycles. So this is beyond one pay period, just to give it a picture for people. So if you haven't gotten any income, this is your income now because you're not getting income. So this is a burden on the person who's been injured too. This is like 2.5 weeks of no income. I'm just trying to translate it
Right.
into reality.
So this,
Okay,
It's actually more than, it's more than 3 weeks because it's 21 days after it was due and it might already be a
Oh.
week after.
oh, so this is after it was due. Oh, right, it
Right,
says
so
after
the insurance
becoming
company
due.
may pay a week, issue the payment a week after, a week after the pay period it was due for. And then this is 3 weeks later than that.
Okay, so it could be, so this, I'm just trying to understand this. This is quite could be a substantial period of time with no income. Okay, that's all I'm trying to understand. Great. Thank you.
okay. So on page 13, starting on line 11, so this is a separate penalty. So this is when you have a date that the benefit payment is supposed to be mailed or deposited. And if you fail to mail or direct deposit the payment on that day, there is also a late fee equal to the greater of $10 or 5% of the benefit amount. So for most benefits, you're going to be at the 5% range. What the bill would propose to do is that first time you're late, it's 5%. Second time you're late, it's 10%. Third time it's 15%. And then fourth and subsequent times it's 20%. So this is a separate penalty that you get for missing the day the payments are due. Again, I would leave it to the advocates to discuss the pros and cons.
But again,
of
this is the
proposal.
insurance company, not the.
Right, so this is an additional amount. Yeah, one thing to keep in mind with workers' comp is when we see employer means the employer and their insurer.
Right,
So,
that's what I'm trying to clarify all of it.
Yeah. yeah, so it does trip your brain up a little bit as you're reading it because we say employer frequently there, but we define that to include their insurance company.
Okay.
Can I ask
Do you
you,
have a- yeah.
Oh, I'm
Randy, do you
sorry.
have a question? Wendy,
does the actual employer get notification when the insurer is late on payments? Because if I were an employer, I would want to know that the insurer is getting behind on payments.
I'm gonna phone a friend on this one too. So,
I don't think they actually often do know. Maybe the self-insured, because they're working with their third-party administrators and they're much more closely looking at benefits and things and what's being paid. But I don't think in most cases employers know unless their employee happens to say, your insurance company has been late paying me, and I just don't think they're aware of it most of the time.
All right.
Employer.
There's not, to my knowledge, a whole lot of communication on a regular basis about between the carrier and the employer. You know, once the claim is presented,
Okay.
you know, most employers just basically leave it up to their carrier to adjust the claim.
So I'm gonna assume you're fine.
Oh, yeah,
because-
it's just
okay,
my
Okay, yeah.
tip larynx.
So-
My committee is very used to
Yeah.
my tip larynx and the spasms
So
produces.
just, we might want to think about having, maybe when the insurance company sends the bill for the year, letting the employer know, give them a heads up or, and, you know, a statement about how, if they've had a problem or if they paid penalties.
I expect to speak to the penalties. I mean,
Okay,
Jamie's on behalf of American Property Casualty Insurance Company. What I'll say is, you know, we're not sitting on our side of evidence of a lot of late payments. So we
okay,
wouldn't
good.
necessarily see that as a, you know, why do that? In other words.
Okay.
All right, so we're gonna hear
Well,
from Jamie
Yeah,
in
yeah.
a second.
I mean, I just think generally the employer should know.
I think a lot of
If it's
these
a
things
big
are
issue.
there for the outliers that every once in a while you get an insurance company that might not be up to snuff. But
Right.
I haven't heard this being an issue. And Jamie has a rented seat in my committee.
Yeah.
Okay, let's keep going because we're cognizant of our time. We need
Okay.
other people to hear from.
Okay, so section 9 relates to costs and attorney's fees for proceedings when there's a dispute that goes before the department. So what this is seeking to do, as I understand it, is clarify the status quo. So you'll see struck through language in subsection A. And then in subsection B1, we're providing that when a claimant prevails in either a formal or informal proceeding, the commissioner shall award necessary costs incurred in relation to the proceeding, including deposition expenses, subpoena fees, and expert witness fees. And then the commissioner may allow the claimant to recover reasonable attorney's fees. So it's a shall on the costs, a may on the attorney's fees. And then under 3, if a formal hearing is requested and the case settles prior to the formal hearing, the commissioner may award reasonable attorney's fees if the claimant retained an attorney and the payments were made to the claimant as a result of the attorney's efforts. So in other words, the attorney in the action taken before they got to the hearing stage was able to secure a settlement. And then the commissioner shall award, you'll notice shall is highlighted. That's just because in S101 it was may. And my understanding is that may would have actually been a change from the status quo, but shall award necessary costs if the payments were made as a result of the costs incurred. And again, I would defer to the advocates to talk to you about what those costs might be in a typical situation. And then the changes in subdivision or subsection C are just technical changes to bring it in line with our current drafting style. And in subsection D, that's just renumbering. And then you'll notice in the old subsection D has been struck out, and that's because we moved the language up into the new
Right.
subsection D. So this is nothing that we're actually deleting, it's just been moved up.
And the last piece from that we've taken is
Right.
adoption.
Yeah, section 10 from S101, or the last piece of S101 that's added here is section 10 is just rule adoption. If you keep sections 4 through 9, this would stay as it is. If you decided to only take some of these sections, we would amend this section accordingly. And then I would defer to the Department of Labor as to whether or not a year is enough time for them to adopt and rules necessary to implement those changes. Begin with section 11, we're incorporating language that passed out of the House as H55.
And this is our UI. Now we're shifting to UI.
Yep, so we've shifted over to unemployment insurance. The changes in section 11 are adding a definition of son, daughter, and child. And then in subdivision 26, adding a definition of spouse. And the change that the Senate would be proposing here would be to clarify what a domestic partner is, and defining that as someone with whom the individual has shared a residence for at least 6 months. Both of them are at least 18 years of age, and they're not married to or in a civil union with or considered the domestic partner of another individual. They're also not related by blood closer than would bar marriage under state law, and they've agreed to be responsible for each other's welfare. So this is reflecting how we define domestic partner elsewhere in statute, without cross-referencing a statute that says the candidate's spouse or an individual with whom the candidate lives. So our prior practice was just to reference election law.
Got it.
Interesting.
And we've started spelling it out because people say, well, the
Right. Well,
worker
there are
is not a
challenges, my
candidate
guess.
for office.
Yeah.
So,
It does cover the waterfront.
yes.
It's, as they say, fulsome.
So,
The waterfront changes.
Yes.
Changed dramatically, I thought, in this building.
I mean, in our lifetimes, just think about it. Okay, so,
so section 12, this would take effect. This has a delayed effective date of 1 year. And this amends the definition of employer in the unemployment law. And the changes are, or amends definition of employer and employment in the unemployment insurance law. The changes are primarily technical until we get to page 20.
oh, good, cruising along here.
And on page 20, you'll notice this is referring to nonprofit
Oh, right.
nonprofits. So we're now making nonprofits with fewer than 4 individuals in employment. So fewer than 4 employees subject to unemployment insurance, but we're delaying the effective date by a year to allow time for the nonprofits to budget for this change, because they'll either have to start setting aside money to be able to reimburse the unemployment insurance trust fund for benefits paid, or budget for regular unemployment insurance taxes.
And if we could just remind, Wendy, this was an issue during COVID.
Okay.
And, right, am I wrong in thinking that this is a
Well,
catch that we caught in COVID that we needed to,
This was an issue that had come up prior to COVID.
right, but it really
but it
became an
really
issue.
became more significant during COVID because you had, with the way the economy shut down, we have a number of small nonprofits in the state,
Oh,
and a
huge.
number of people who thought that they would be entitled to unemployment insurance benefits for their work for those nonprofits, and then found out that they were not covered because the nonprofits were below this threshold. And the nonprofit coverage can change from year to year because it looks at 20 weeks during the year. So if you had a year where you had 4 or more employees, you may have been covered. And then for the next 2 years after that, you might slip below the threshold and not be covered as an employer anymore. So, and the department can speak to this a little bit more, but it became a much more prevalent issue during the pandemic. There had been talk before of just requiring notice. But one of the tricky things is we don't have a great handle on how many small nonprofits we have in the state, and the department would have no way of enforcing a notice requirement.
Oh,
So
maybe we need a nonprofit registry, just like, but actually we now have a better,
so
yeah,
you'll see in the next sections, we actually talk about working together with nonprofits and the Secretary of State to reach all of these small nonprofits.
yeah.
But before
So-
we get there,
And we of course have Common Good, we now have an organization who has a really good handle on this. Plus we have the Arts Council, the Humanities, and we have so many and
But there are so many, they can pop
Oh.
up overnight
dude,
and then go away overnight. I,
don't know how they're pretty solid. Most of them are all organizations we are on the boards of, so. There are thousands of them, and I think Woodstock has the largest number of nonprofits registered in the state.
Yeah, they have to register, right? And
Yeah,
so-
that's why the
so I mean,
Secretary
there
of
is
it's a federal tax.
Yeah.
It's
so
now-
they're either interesting or not. It's not a,
That's why this includes the
Okay.
Secretary of State, and
Right,
that's in
and we'll
section
get to
B.
that.
okay.
So
Okay.
let's pause at
Keep going.
section 13 first, though.
Section,
13, which is a very long section,
yes, it is.
mostly makes technical changes. So that begins on page 20. The changes are technical.
Oh, we may need a haiku.
You'll notice a lot of struck out language. If you look at it closely, you'll see that it references changes in the law that occurred in 1971 and 1972. So we're striking out that language because it is obsolete at this point. And the technical changes continue through page 22, where changing phrases may change to a reimbursable basis to may elect to become liable for payments in lieu of contributions. So contributions is the euphemism we use for unemployment taxes. And then
Which
so
does become confusing with nonprofits, where contributions mean an entirely different thing.
right. So payments in lieu of contributions, nonprofits, municipalities in the state of Vermont, nonprofits can elect, the state is required to do that, and I believe municipalities can elect to. Is that right, Cameron? Yeah, so municipalities and nonprofits can elect whether to be taxable or to make payments when they are due. The state makes payments when they're due. And then you'll continue looking down here, page 23, more technical changes.
Yeah.
Page 24, more technical changes. Page 25,
This is
more
all
technical
technical.
changes.
On to 26, which has almost no changes.
Yep, more technical changes on 26. Page 27, more technical changes. Page 28, more technical changes. You'll see that a lot of this is cleanup on page 28. The thing to note is that the big strikeout there is language that was redundant. So we essentially repeated the language, virtually identical language for two separate scenarios. So instead of that, we just combined it into one paragraph.
And that's the same for page 29.
Page 29, same thing. It's all part of the same combination of language. Page 30, more technical changes. Big strikeout at the bottom of page 30, top of 31 is all language that related to transitions in 1969 and 1972.
Wow.
Look how many-
Historical reference. You're
Yeah.
deleting the historical reference.
That's
I
okay.
am.
Tanya Marshall will have it in the archive.
We've got it in the
Yeah,
legislative library too. And then more technical changes on page 31, which brings us to the end of that section. So that section,
That is a long section.
that section is unbelievably long. The goal was, because we were updating this,
might as
to
well.
actually make the language a little more clear for people who are now becoming subject to the law.
I know. Now I'm feeling though that every technical change requires a haiku, so it may have to have its own little haiku here.
Well, I will look forward to that.
Yeah, I know. And I love that the lieutenant governor countered with his haiku of his own. So it's kind of fun.
So section 14, this is education and outreach that we talked about earlier. So on or before October 1, the Department of Labor, in consultation with VLCT, Common Good Vermont, United Way of Northwest Vermont, and other interested stakeholders would develop information and educational materials regarding the UI system. Numbers 1 through, or subdivisions 1 through 5 include the specific minimum information it needs to include. And then subsection B requires that the information be made available on the department's website, and then in coordination with the Secretary of State. And the organizations listed and other interested stakeholders would be shared directly with nonprofit and municipal employers to the extent practicable. So to the extent we can reach them, disseminate that information directly so people don't have to, also people are not relying on either being aware of everything that happens in this building or all the changes on the department's website. And then subdivision 2 requires the Secretary of State to assist the Department of Labor in identifying and contacting all active Vermont nonprofits and to make available on its website a link to the information and education materials. So if you're registering a new nonprofit, you would have a link to this material and hopefully have up-to-date information on your unemployment insurance requirements.
Oh my gosh,
And
that in
then
there.
subsection
Hoping this-
C
Yeah.
requires the department in collaboration with the stakeholders to hold one or more informational sessions to present the educational and outreach materials, and then to allow for both in-person and remote participation, and then to record the session and make the recording available so that there's a webinar that new nonprofits or nonprofits that missed the session can view and get educated on the changes.
Perfect.
Yep, and then section 15, this is a cleanup change. This relates to the supplemental unemployment insurance benefit. The $100 million supplemental benefit paid out until the $100 million runs out. As I mentioned, when I walked through H55 the first time, there was a drafting error that Mr. Wood caught early last summer. And so this is correcting the error and making sure we calculate all of the additional or count all of the additional benefits paid out the way it was drafted before. We would have inadvertently undercounted the amount of benefits paid out.
So this is for the overpayment?
So this is
I thought
for the
this was
supplemental
For the,
benefits,
there,
the
$25. This is for,
the
so-
$60 increase in the max, and then the
and the 25
$25 increase in the weekly benefit amount
So-
that'll come later.
for Ann and Wendy. This was what we worked out as a balance for what the benefit that the employers were getting as a result of the infusion to the
Right,
UI
so
trust fund.
there was a negotiated compromise
And
where.
This is, so we wanted to make sure that employers and employees, people who were on getting UI would benefit from this.
Right, so we
would you-
artificially held down the unemployment tax schedule over the next 10 years by the way it's calculated. You look back at your worst year in the last 10. We took the COVID pandemic year that had the huge unemployment rate out of the calculation, because otherwise that would have had us running to a reserve that was far outstripped anything we'd ever needed in the past. And so that was calculated to hold down taxes by roughly 400 million over 10 years. And then the compromise was to pay out additional benefits of $100 million until the 100 million is spent, because we can't predict the economic cycle accurately enough to say it'd be 10 years or 15 years or whatever it is.
So it's now getting implemented, but because it wasn't, because there was a drafting error,
There was a drafting error that would have had us paying out more benefits than we had agreed to.
Right.
So this is to preserve the actual compromise that was agreed to, which was 100 million in additional benefits
To whom?
to unemployment insurance claimants.
To the,
yeah, to the
to
claimant.
the,
So
This was-
to the unemployed
People
individuals,
themselves.
right? So
This was designed to balance, and so
Okay.
that both parties would benefit. There's
yeah,
still the employee in the people on UI still, it's much smaller, but it is, it struck this committee as being a fair balance, and we negotiated that. It was not an easy negotiation.
right. So this is what came out of the conference committee.
We were on that
We
together.
were on the conference.
Yep. Yeah, when I drafted the compromise, the way I drafted it, I inadvertently left out, didn't consider something in the draft. And so that would have,
Moving fast. It's hard.
it was moving fast, and I appreciate that. And I appreciate that Mr. Wood took a close look at it over the summer and called me up and said, hey, my math's not working out.
Well,
We looked
that's-
at it and figured out language that made the math work out.
Well,
So,
thank you. And we appreciate
so
this moving forward. Great. And so section 16, because I want to be able to shift to our,
yep.
um,
Section 16 is a report from labor prepared in consultation with JFO that would relate to extending eligibility for unemployment insurance to individuals who separate from employment due to urgent, compelling, or necessitous circumstances, including something like the individual's injury or illness, obtaining or recovering from medical treatment, escaping domestic or sexual violence, or caring for a child following an unexpected loss of childcare, or caring for an ill or injured family member. This was a proposal that was in another bill in the House. And the proposal would have implemented this, and the House's compromise was to study the issue and then come back when they had a better sense of what the potential impact on the trust fund was. So this will look at that impact on the trust fund. It'll also look at states where they have implemented some form of this. So some states have implemented this for like one of those scenarios, and others have implemented it for more than one. And this will take a look at that from a variety of angles, and then include estimates of the potential impacts to the trust fund and a recommendation as to whether there should be legislative action. And then section 17 is a report on the utilization of the Domestic and Sexual Violence Survivors Transitional Employment Program, which is an alternative to unemployment insurance for individuals who have had to leave employment because of domestic or sexual violence. And it will look at efforts that the department has made in the last 10 years to increase utilization, and identifying how those changes, or how the changes have impacted utilization, and then identify any other ways to increase utilization. This was for years an underutilized program, and the department has made significant efforts in recent years to improve awareness and utilization. And this will give us some data on how that's going and whether there are additional changes going forward. And then section 18 adds a notification provision to that program for the department to work with states attorneys, law enforcement, community justice, organizations that work with survivors of domestic and sexual violence, the Center for Crime Victim Services, and the Network Against Domestic and Sexual Violence, to develop better outreach on the program. And section 19 is your effective dates, and that's it. I'll yield to your other witnesses.
thank you. Thank you. So this is the, this is where, that was very helpful to get our heads back into this. And I think Jamie has kindly offered to go next every time we've run out of time. So we're going to start with Jamie.
Kindly offered, right? Thank you very much.
Well, you agreed without too much fuss, so that's kindly offering.
Thanks for,
Yeah, thanks.
confinement.
Because we run out of
Are you all
time
right?
all
Yeah,
the
no,
time.
no, General Chair.
No,
Good morning, Jamie Phelan with Kramer Piper Lacy Kramer on behalf of the American Property Casualty Insurance Association. APCIA, in addition to being a mouthful, is a national trade association of over 1,000 property casualty companies writing all lines of insurance, including workers' comp, several members of whom do that here in Vermont. I have previously spoken briefly on H217 as it came over to you, but I will just, for refreshing memory, speak even more briefly to those provisions. Those are sections 1, 2, and 3 of this new draft. Sections 1 and 2, APCIA is largely neutral. This, sets the annual contribution rate, and that rate is what it is every year.
Right.
Section 3, my understanding is it will make permanent the ability to object to discontinuance and seek a 14-day extension otherwise subject to a January 1 repeal. I believe that's the date. And again, as I previously stated, APCIA doesn't see a problem with this in actual practice. It's not being highly utilized. And this is maybe one of those examples where changing the rules again may be more problematic than sort of putting in statute something that has been.
But you're okay with sections 1 through 3?
Correct. Section 4 begins S101. So I think I've updated my notes because until this morning I was working off the bills introduced. So I think I've got the right sections now. And, this one, 101 has, it's a mixed bag. It's got a lot of proposals in it, of course, as you just heard from Legislative Council. But overall, we look at the amendments as unreasonable, adding costs to the system and thus oppose them. But I'll describe that further as I go along. First, to be fair, there are some provisions that are reasonable. Section 4 that calls for extending pre-authorization to surgical, medical, and nursing supplies, we don't see as problematic. Section 5 for the provisions regarding work search also seem reasonable. Section 6 through 8 are sort of the meat of sort of where I'd like to focus. We do have some questions with the proposals to recalculate benefits and the cost of living adjustments, but in the interest of time, I'll focus on a couple of other things, and I'll slow down now.
So you're basically okay with sections 1 through 5, and it's 6 and 8 through 8 that you have.
6 through 8, yeah. Because there's a lot of proposals within each of those, so I'll try to parse them out. I'd first like to speak to the child dependent proposals in sections 6 and 7. And again, to restate my understanding of what's being proposed, this will add a new child dependent benefit for a worker receiving temporary partial disability benefits, and specifically $20 for each dependent child under age 21. That is, if you're looking.
Okay, so what page, on pages 7 and 8.
So you said a new benefit for temporary partial?
Correct.
So there had not been a
There had not
benefit
been a child benefit for this.
for temporary partial.
Correct. And this is at the bottom of page
7.
8.
The bottom, page 8.
Line 19, or paragraph beginning line 17.
Right.
In addition, it proposes to increase the existing child benefit for a worker receiving temporary total disability benefits from 10 to 20. So I know, much has been said about the length of time between now and when the last child benefit was adjusted. But I ask you to sort of take a step back. When we're talking about workers' compensation, we're talking about a wage replacement program. We're not talking, for example, about a life insurance policy that has the dependent sort of feature to it. We believe that the wage replacement discussion is the appropriate place to consider, these sorts of things. I mean, there's a cost of living adjustment that's in the bill and will continue to remain in statute. We just sort of, perhaps it's a philosophical argument that was probably, waged decades ago. And there's probably good reason that it hasn't been adjusted over time, perhaps because of that policy, that this is really a wage replacement benefit and not a benefit that considers other types of, such as a child dependent. So if you decide to keep these two proposals, we would ask that you keep them modest and certainly not as set forth in the proposal.
So to translate that for me, what you're saying is that there already is in provision of the wage replacement calculation, a cost of living adjustment, and that so the cost inflation is already taken into account in the wage replacement calculation.
As one factor that will continue to move, but also the wage replacement in general is sort of the
Right.
I think what I'm hearing is that this is a wage replacement, not a charity program. That you want to make sure that the wage is being replaced. That's your wage. When you got your wage, it didn't matter if you had children or how many children. And then if we're going to adjust, it should be done as part of the wage replacement, not by adding an extra benefit.
However, the extra benefit is already in
is.
statute. It already exists.
Agreed,
So, and it hasn't been adjusted for 42 years.
agreed. And to restate, you know, I think because there is probably this philosophical policy discussion or, you know, that has probably took place, it wasn't us 40 years ago or even in 1981. When it was.
But it's been in statute since
The
59,
one benefit is not,
Yeah.
there is a new one.
not for the temporary partial.
But people did have a lot more children in 1959.
That may be true too. So we have fewer children, so the
You're
impact.
saying is that a benefit like that should lead an employer, if an employer were able to do it, to charge a higher rate for covering those employees who have children.
No.
Perhaps.
That's a challenge.
I think it's sort of.
That's the only remedy, isn't it?
Well, it's the, you know, the factors that go into the calculation of the wage replacement, I think is, you know.
Okay, let's keep cruising.
Yeah, actually, I just have
Yeah,
a question, because sometimes people are out for just 3 days or so. So when does workers' comp kick in? Or do you go back to day one?
I mean, can I phone a friend? These practitioners are much better at
Yeah,
this.
sure, I think.
A fair amount of them are short in my
Well,
experience.
we'd love to know what the person, again,
After 3 days of being out of work, the temporary benefit kicks in and it pays back to the first day of.
Okay, that might be why 3 days is in my head.
If somebody's, sorry, Kevin asked that, if someone's only out 1 or 2 days or 3 days, they're not gonna get the TTD, the temporary benefits, they have to be out more than 3 days.
Okay.
okay,
The next issue is also in section 6, and on page 9, I believe. Yes, this is related to the date of benefits.
the 7,
Yeah, this is page 9, it's like line 6 has 7 days for current employer, and then later on, there's a separate proposal for 3 days for if you're working for a different employer.
right.
And again, this is setting, this, in the first instance, the insurer must make payments of benefits within 7 days after the claimant receives its normal wages. In both instances, this is setting something new. My understanding is there's a 21-day default period that may or may not be widely utilized, hopefully not. But so this is sort of setting a new timeframe. You know, we haven't heard yet to date, at least any sort of compelling evidence that would sort of set an arbitrary date, whether it's 3 or 7. Certainly 3 days for the other employer sounds pretty tight. What if you receive notice on a Friday, for example? Certainly don't understand the discrepancy on the 2 days. Why, or the 2 periods, why 7 for one and 3 for another? So we would ask you at a minimum to consider some more time. And in addition, if you do agree to make the 2 dates.
To make them consistent is what your request is.
Rather than lead to some.
So we need to understand why they're different.
Just a question for the.
Yeah.
Village council, is it day, and we don't say elapsed days or calendar days or working days, is there some assumption that we make?
I would say if you want to specify business days, you should be clear about it.
Because otherwise, the elapsed days or calendar days is the default.
Yeah.
Isn't that the assumption? I mean,
But we
it happened.
shouldn't- It's not good to
No,
assume.
never
I
say.
No, I-
believe that for a standard rule is that a day is a day, calendar
Yeah.
day.
Yeah,
So if you want it to be business days, say business days.
all right, well,
Yeah, because a holiday
We should think about
weekend,
that,
you
yeah.
get notice on Friday, you can't even get anything in the mail until Tuesday.
Okay,
And we
Thanks.
won't talk
Somewhat-
about mail delivery.
Thank you. Shifting to the penalties that are
okay.
proposed to increase. And I'm going all the way to page,
Section 8 now.
yes,
right?
section 8, page 12. The first is found on line 6, where the current penalty is proposed to be increased by 150% for orders of the commissioner. or in cases in which an overdue benefit is not in dispute. And then I'll sort of take these in their entirety. Then moving to page 13 is a new, beginning on line 16, is a new sort of graduated penalty structure for payments based upon number of instances. In both cases, we think these are rather large increases, particularly when we haven't heard to date any sort of compelling reason for change other than, these late payments happen all the time. When I heard that, I went back to our folks and sort of double checked and said, hey, what are we hearing? And they didn't get a resounding chorus, so I pushed further, went to one large writer in Vermont, and they gathered their team and said, hey, what have we got? And they had to go back a couple of years and found one instance where a sort of direct deposit was being bounced back. It was sort of an inadvertent, it just wasn't catching. And that was all that they had found in terms of late payments. So I asked them for other scenarios, and one might be, for example, when they're waiting for a check stub from the claimants getting temporary partial benefits. So I guess what I'm trying to say is we don't hear from our perspective, certainly not the data or the justification for such penalties. Moreover, I would think we would also hear from the Department of Labor in orders, conversation penalties, et cetera, that, hey, this is a problem and we're not seeing that as well. So we would ask you to leave both of these proposals in their entirety in the absence of such data or compelling reasons.
Okay.
And lastly, on section 9, related to costs and attorney's fees, it's been presented that this is merely restating existing practice. If so, we would suggest that that's redundant and therefore unnecessary. Our concerns is, when you restate something like this, that you reopen something subject for different interpretations.
I'm sorry, can you tell me?
So sorry, where are we again?
Section 9, page 14. Yeah.
So the shall awards and the may award, I thought this clarified the status quo.
That's what has been presented. It very well may, but I think anytime you try, because it's now covered in not only in the struck language here under 678, so section A, but under department bulletin. I've got it in a file over there, or guidance. But it just, our concern is going to lead to questions of interpretation, and further, if it isn't a clear and accurate restate, what is changing, and how will that be applied or interpreted? So if it's restating, we'd rather keep with where we are rather than restate.
So
A lot of unintended consequences.
so the restatement is, your concern will lead to misinterpretation. Yeah.
Correct.
Okay.
And we have no comments on the,
Randy?
I don't see this, I don't see how the basis for the claim of
Yeah.
potential
I
misinterpretation.
think it's
Pretty
If anything, it's
straightforward.
clear.
it's combining what has been sort of vetted existing practice through either existing statute or the department guidelines. And putting it here, we just think could be problematic.
Okay, and keep going, keeping
That's it. We have
moving
no other,
along.
we're focusing on the workers' comp, have no interest in the unemployment provisions.
Right.
The balance of the book.
Thank you.
Because the insurance companies are not involved in that. Okay.
So, I hate to ask the obvious, but if there isn't a problem, why are you worried about it?
There's a problem with,
If there isn't a problem with insurance companies not being great and paying on time, if there isn't a problem, why are you worried?
because
about
I think, for the penalties, because of the unintentional, none of these would be intentional withholding of payment. It's the direct deposit bounce backs. It's the, as I say, waiting for the check stub. And to have sort of these, what we view as sort of pretty significant penalties for unintentional one-off accidental errors, we just don't see, particularly in the absence of that this is a systematic problem that we're trying to address.
Okay. Anybody else have a question?
I will be
Okay.
right over here. Since the question.
Great,
Thank you very
Dirk.
much.
Do you,
If you've only got 7 minutes left, I'd say probably here. Kelly. I mean,
Okay.
it's up to you.
We could, if you would be willing to come, Cam, do you have something you want to say?
That's what I was about to say. We would like to speak on the bill, but we're happy to come back.
Okay,
I can be, I mean, you guys
Okay.
go.
so if you could be quick, Kelly, go for it.
Well, I fine, I was gonna suggest they go
Yeah.
first.
Okay, so Department of Labor, why don't you go first?
Okay.
Wendy, what's your?
No, I would just be really, no, go ahead, please. Just data. I mean, we've heard from the
Yeah, we can
insurance industry that there isn't evidence of late payment. Does the department keep that?
Okay,
evidence?
so Dirk, we're gonna give it to you to answer.
Okay,
Answer some of-
thank
How are you feeling about it?
you, Chair. Dirk Anderson, Director of Workers' Compensation. And the reason I want Kelly to go first is because, and we're speaking again to the penalty provisions in the bill.
So you're okay with everything up to section 9, up to section 8?
Let me first say that I'm thrilled that all the parties were able to agree on at least some of this bill.
That's good.
So we're very happy with that. And again, this all originated with what I'm most concerned about on behalf of the Workers' Compensation Division are sections 1 and 2. Because going to the last day of the session without knowing if your program is going to be
Yeah,
funded
got that.
is very stressful.
I've
So-
lived through,
So
I
you
feel like
like
we've
this.
lived
I
through that
like
recently.
Good, okay.
And some of us are concerned because we've lived through it. So
Yeah.
we're right with you.
Section 3, we're fine with, and as is everybody else. Section 4, section 5. There's no real disagreement there. Section 6, temporary partial disability benefits. Actually, let me back up, because where I started with was you've heard from the insurance industry that late payments.
Will you be back?
Yes, I just have an afternoon committee issue.
Right?
So you've heard from the insurance industry that late payments are rare. You will hear from.
So sorry, where are we section?
I'm sorry, I am jumping ahead. Maybe I shouldn't jump ahead.
No, you're welcome.
Okay.
We're nimble.
So we're talking about the penalty provisions
Section 8.
of section 8. And again, you just heard from the insurance industry that late payments are unusual and certainly unintentional. You will hear from the claimants bar that they happen all the time. You will hear from me that all I have is anecdotal evidence. I have seen since I've been director, which has been 1 year and 4 months now. I have seen a handful, maybe somewhere between half a dozen or to 10 of pretty substantial late payments rise to my attention. Is that enough to justify raising the penalties as much as is proposed? I don't think so, but again, all I have is anecdotal evidence and.
So the department doesn't get notified unless a claimant comes and says, you know, I'm just giving you a heads up that this insurance company is really slow or whatever.
Exactly, and
So-
that usually comes through people like Ms. Massacott, who advocate on behalf of their clients. A lot of claimants, they may get paid late and they may be like, well, I got paid late, bummer, but they, you know, they don't necessarily reach out. So
Okay,
all I have
so-
to work with is
you
anecdotal evidence.
Aren't informed, yeah, you aren't you aren't directly informed of these things.
Correct.
So
Anecdotal.
maybe you should be, is what I would say, but that might be a bigger conversation.
That is a conversation that we are having about how to be so informed, and that may include surveying, you know, the attorneys who deal with these, both the insurance bar and the claimants bar. Asking my specialists to track late payments as they see them. So I'm willing to try and gather more information to the extent that I can.
Great.
I don't know.
Yeah, we'll have more time to talk, right? But
Yeah, and we
but
have
you're
Kelly
getting a
coming.
new, you're developing a new system, aren't you?
We are.
I mean, can't you automate that?
The new system, when it is up and running on November 7th.
Oh, you're kidding. We have a real date?
Oh, yeah. So far.
Wow.
Things are going pretty well with our new system, and we'll talk about that another time.
We want to be
But
invited.
that should be that should be able to better track late payments, absolutely.
Okay, good.
Okay, so backing up. Where did we stop? All agreed.
You were
Section 6.
Section 5, I think, we
Yeah.
were all in agreement. through
Everybody's
section
good
5.
with section 5. Section 6, we support the recalculation of the way that temporary partial disability benefits are paid, because we believe, we agree with Ms. Massicott, that the way that they are currently paid can result in low-income earners actually making less in benefits plus salary earned than they would if they were on total disability. So, you know, we addressed this problem, those of you who were around the Shumlin administration, we addressed this problem on the UI side by changing the way we pay partial benefits. And the intent behind this change, and I think it's a correct intent, is to not create a disincentive to go back to work if you are able to. So we support essentially what is section 6, 646A1 and 2. When you get to the language on page 9 about.
So you support the new benefit for child dependency with temporary partial.
That would be a new benefit, that would be a cost to employers indirectly through their
That's
carriers.
pretty.
I mean, any additional cost to a carrier does eventually wind up making its way down to the
But you
employer.
basically support that new, it's consistent with the other benefits.
Yes, so we support the recalculation,
Yeah, got that
and we support,
on section 6. They support the recalculation.
so on page 9, we agree, and I think we think all sides agree that there shouldn't be two different payment periods.
That make the days consistent between 7 and 3.
Make the days consistent. We tried to all arrive at a number. I don't think we have done that. But
We'd
it
love
should-
to have you continue that work in negotiation and see if we can come back with a consistent date.
Okay, but I think we all agree that that should be one number.
I would think
Whether
that
it's
was a good
7
idea.
Or 10 or something
Right.
else.
I think we would appreciate your coming to a landing.
It says mailed or deposited, is that correct?
So the language was changed to after the insurance carrier receives the wage information. That was your request, Senator.
Mhm.
And
Okay,
But
so you
in terms
still,
of dispersing money to the claimant, it has to either be mailed or deposited in the check. Can it be mailed from Bora Bora or Bangladesh, third class? And I think that's likely,
well,
unless I
You could
want
try
to prove my
Canada.
tax
Give 'em
law.
I think we all agree and prefer direct deposit because it's, you know, it's direct and you can trace it and, but not everybody is, you know, has a direct deposit. There are unbanked claimants that rely on the mail, so
right,
we can't force direct deposit.
this is true. We
Well,
have,
again, it's a minor thing, it's unlikely, but should be somewhere in here to say that United States first class bail.
and so what line?
It's mailed or deposited is the language.
Yeah, I said mailed or deposited into the bank account. Deposit bank account is clear, mail, you know, again, unlikely, but
Yeah.
some of these are set by insurance companies, some of them are set by employers, I think. Who have,
Not so
Self-insured,
much, I don't-
self-insured employers, but there aren't that many of them.
So we can flag that.
Mailed or deposited into the injured employee's bank accounts. I'm okay with that.
Yeah. Okay, so we're still working on consistent language. You're still going up to the cafeteria to keep that work going. And the next is section 7.
Section 7 TTD, again, we support the clarification on the 26 weeks prior to getting to COLA. That's already the law, we believe, but this clarifies it. We do not necessarily support the increase in the dependency benefit.
Why not?
Because it's represents a cost to employers indirectly through their carriers.
So is that consistent with section 6? Do you support the addition of the child benefit in section 6, no matter what the size is?
We do not.
Okay, so you don't support the new dependent benefit.
So this is more with the insurance company argument that this is wage replacement, not a social benefit program.
Well, we recognize that the dependency benefits has been in the statute since 1959. We're not advocating that it be removed, but we're also not supporting its increase. Its expansion.
So it's increased in amount where it exists and the increase in the benefit on the temporary partial. So those two things you don't support.
Correct.
Okay.
They don't support.
No,
the
I'm
increase.
just double checking.
Yeah,
Okay.
okay, so we're clear on that. Are you continuing to work on that? Do I understand correctly that this is a continued negotiation?
The continued negotiation may be possible as it relates to the 7 days, 3 days language. I don't think we're gonna come to an agreement on the dependency benefit.
Okay, so you're still negotiating the consistent dates. Right, okay, but not on the benefits. Okay, so section 7, we are,
Section 7,
that you don't support that increase.
the dependency benefit.
Right.
Correct.
So section
Section
8, the
8,
penalties. You've heard anecdotal evidence.
Again, I don't have enough actual evidence of a problem to support an increase in penalties. Section 9,
Although you have heard some anecdotal evidence. that this
it
is
does
wrong.
happen. I just don't know how often and how widespread.
So you don't have enough information to really weigh in on that.
If you had I can see, somebody's direct deposit bounces back because a number got transposed. Things can go awry once. Would you know if you had consistently bad actor A?
Well, I can say anecdotally, and Ms. Mascott may remember this because it was her firm, we did have a case where the claimant's attorney came to the department and showed us documentation of a carrier whose payments kept falling off. The claimant's payments kept falling off their radar, and they said they were trying to address it, but we didn't really see them trying very hard. So in that case, we have the authority, I have the authority, the commissioner does, to issue penalties under, I think it's Rule 45, when we see an employer or a carrier failing to fulfill their obligations, and we did in that case. But again, that's anecdotally, that's one.
I'm just wondering, is there any inconsistency regarding mailed or deposited? Says here, essentially shall be made by direct deposit to a claimant who elects that payment method.
Sorry, what
I'm on page 13, and this is existing language, page
7.
13,
Line 7.
lines 7 and 8.
So it's the mail or deposit. I think that's a question for Kelly, because I think she has more claimants and is clearer on where the challenge is.
Yeah,
So
whether or
let's-
not there are employers or senders, if you call it that, who don't use direct deposit and don't have it available.
most
Okay.
I mean, most insurance
carriers
companies would.
all
Carriers.
have that.
Kelly, do you have an answer for that?
I believe that it's mandated that carriers have to offer direct deposit. A couple of them were slow to get moved over to that format. The good thing about direct deposit is there's proof positive now when a late payment is issued.
Yep.
Previously, because it's bulk mailing, you didn't know, was it the post office, and now with direct deposit. So perhaps the issue of late payments is going to be more recognizable now that more and more people are on direct deposit.
Are there still some who are not?
For sure. I have some clients that just don't feel comfortable, they're old school and they bring their check to the bank. Yeah.
Or they're unbanked?
Yeah.
Or they're unbanked, yeah.
Section 9, We believe that these changes really just mirror existing law and practice. We're not necessarily, we don't think they're necessary, but we don't,
You're not going to oppose.
I'm not gonna.
Okay,
Yeah,
you're okay with it. And you just, they change, okay.
can I just, so
Yeah.
I didn't hear that you opposed the increases in penalties, but just that you don't have data that there is a problem.
At this time, I cannot support the increase because I don't have sufficient data.
So cannot support is
Section 8.
similar to oppose, but not exactly the same.
It's correct. But they don't
Okay.
support it.
Okay.
They don't
Okay.
actively support it at the moment.
Okay,
At the moment.
got it.
Yeah, right. A soft opposition until proven. Okay, so we're now in section 9 and you're okay, but you don't think it's
We're
necessary.
okay, we don't necessarily think we need it, but we don't oppose it.
Okay,
We're okay with the adoption of rules in section 10, and then I believe that's sufficient time frame because we are gonna have to change our rules anyway, once we
okay, so you
move
could
to a
just add
modern
it.
system.
Right.
Because that will change the way forms are submitted and so on. And that's it for workers' comp. If you want to ask Cameron about UI.
Okay, I'd like to finish on workers' comp before we shift to UI, if that's okay,
That's fine
Cameron,
with me.
because we already have abused our break at a bit, but I'd really, with all four.
He always abused.
I know.
Almost the last
Luckily,
time
we
got
don't
a
count.
break.
But yeah, well, we're gonna get a break after Kelly. So we're gonna get a break and we're gonna let Ellen and Elizabeth and Damien maybe know that we're gonna start more like,
Damien, we're gonna start.
oh, Damien. But if you'd be kind of to let Elizabeth Burrows and Ellen know that we're gonna be more like 11 or 11:15 because we do need a break. I think 11:15, let's do that. Because it's just having you all in the room, it's just a better use of time.
Yeah.
Okay,
Thank you. Kelly Massacott on behalf of the Vermont Association for Justice, the claimants bar for workers' comp. As you've heard, there has been some progress in some areas, and we're definitely appreciative of these areas of common ground. I just wanted to focus on the pieces that are not in agreement right now. To start with, I absolutely agree the comp system is not a charity. Those temporary benefits are wage replacement benefits. It's not charitable money. The whole way that the comp benefits are calculated, remember, is a percentage of their pre-injury wages. And I believe that the idea behind it was to mimic after-tax income because workers' comp benefits are not taxable. So I believe this is where the dependency benefit comes in.
Right.
Because if you do an automatic 2/3, but somebody happens to have 2 kids, their after-tax income is different than somebody like myself who has no children. So I believe that it's not a charitable thing. It is trying to mirror what after-tax income would be for somebody, or comparing their gross wages and after-tax income with the comp benefits. So the dependency benefit, as you've heard, was first put in the act in 1959 at $2. It was increased 5 times between 1959 and 1981.
oh, it was.
Yes, and it's stuck at $10 since
For
1981.
42 years.
I don't think that this is actually a philosophical argument and a compromise. I think it's just been ignored, frankly. And I believe the director had done some calculations that he spoke about at the earlier hearing about if you took the original dependency benefit into cost of living adjustments, it would actually be just over $20 a child.
Right.
So I really urge you to consider this dependency benefit increasing to $20. It's not charity. It's supposed to reflect after-tax income. And remember, there's that cap. So folks who have several kids or for whatever reason, they're never going to get over their pre-injury wages. The second one, the dependency benefits on TPD, temporary partial disability. This is true. This is a change. This is new. It's a very small portion, in my view, of people who are getting benefits. I think Dirk Anderson testified he thinks it's around 20 to 30% of people getting temporary benefits are on temporary partial, and this would be a new benefit for temporary partial. But it goes with the rationale of don't have somebody making less when they go back to work part-time and get supplemented with TPD, with temporary partial. It goes with that same rationale because you get the dependency benefit on TTD. You don't get it on temporary total, sorry. You don't get it on temporary partial. So it's about not disincentivizing somebody to try to go back to work while they're in the medical recovery process. This is saying, what would you get if you were out of work completely, including dependency benefits? What did you earn in gross wages working part-time? Okay, that's what comp owes you, is that difference. And it's just simpler math, but I do really urge both the increase of the dependency benefit and for it to be included in the temporary partial benefits. As you heard, I think I absolutely agree. It would be smart to simplify this number of days. I could go into why there were 2 different dates, doesn't matter now because we all agree that it should be 1 day for whether you're working for the same employer or different. I would really urge for the 7 days, just because it's always going to be received on a weekday. 7 days means that it's going to be issued at least, within the following week. If we go to something like 10 days, then that can turn into 10, 11, or 12, depending on when the information is given and the additional 10.
No, your outside limit is 7 here. I mean, you're negotiating between 3 and 7.
Well, I think other folks would rather it be more than 7.
But that's not mentioned here.
That's true, that's true.
So it strikes me that that's not really on the table.
Okay, for the penalties, I can just tell you, this is a constant problem. And the issue is, as folks have said, that maybe it's a day or 2 late and the person, okay, that's infuriating, my check's late, but here it is. I can tell you this week alone, I've had 3 clients who got their checks late or their payments late. It's happening all the time. I really urge the committee to consider increasing the penalties, if not as significantly as proposed here, some other increase to really get the attention of carriers. The statute says shall issue penalty payments, but this is not happening. Carriers are not self-policing and doing this without being pushed. And I think very rarely it's going up to even the informal level of the department to be pushed. And so I don't think Director Anderson is seeing, these are the most egregious cases that he's seeing. And those are with people who are represented and have an attorney who knows to argue these things and go to the department. And so I think something needs to be done on the penalty piece.
Maybe every time you get a client with a late check, you should just email.
Well, I just thought to myself,
And
I often get the indemnity printouts when I come on a claim, and I'm happy to start forwarding those to Jamie and to
I would
Director
encourage you
Anderson to
to
see
just forward them. I mean, if
how
they-
often this is happening.
And so if
Okay, now,
you have a question,
well, just 2 or 3 days. Given the state of the US mail, there are towns in this county that don't get mail 2 or 3 days a week. If my mailman is off, and he is a man, we don't get a delivery that day. So that to me may be more a problem with the USPS. If it chronically happens that one company is 5 days late, that's another issue. Or if, I would assume now that they all should know that the postal service is not as reliable as it was a few years ago. Whenever I buy anything online, they say the delivery date, however, we don't control it, and
No.
it'll be somewhere in that area.
I appreciate your point, and I'm the daughter of a retired postmaster, and I'm so depressed by how the postal system has gone downhill over the last several years. It's infuriating.
No.
I'm on
look to leadership.
I'm on Stonecutter's Way, and we didn't get mail for days and weeks at a time, even though we were supposed to have regular mail delivery, especially soon after COVID. What I'll tell you, Senator Cummings, is it's not when the claimant receives it that this is getting measured by. It's when it's getting issued or
Okay.
deposited. So there were a lot of times in past years, I thought checks were late, but I didn't have the proof because it could have been the post office, absolutely. So now if it's a deposit, I can tell because my
Oh,
client
that
gives me
you
the
can tell.
snapshot of the bank account.
Okay, so this is
But-
not the postal system. This
Right.
is
If it's
Okay.
mailing, the carrier has a printout. I have to trust that that information given to me is accurate. And if it shows that it was issued on time and it was 5 days late, a week late, well, that's the post office and there's no penalty on that.
Right, so
Okay.
you're talking about issue, date of checks issued and date of direct deposit.
Yes,
Okay.
And
not the
they're-
receipt, yeah.
And
Not
are
the
there,
receipt. All right.
and are there consistently egregious companies that, I mean, where
I-
there's.
I can't say companies, there's definitely claims and certain adjusters. I mean, I have one, again, it didn't go to the department because it resolved and we settled it, but I have pretty lengthy spreadsheets over the course of this gentleman's claim. I didn't represent him for the majority of the claim, but his claim went on for 3 or 4 years, including the permanency benefits where somebody can still be working and getting those. And those payments were like, they didn't give the COLA, they didn't give the dependency, and they were late. And I have a spreadsheet that I'm happy to share with Director Anderson as a example of some of these cases where it is real egregious. And I didn't go to the department because I didn't want to duke it out of the department when both parties had an interest in resolving the case. And so it was kept between the parties. And so the Department of Labor wouldn't know about that really egregious example. I went to mediation and said, you guys owe penalties on all of this. And they had to admit they did, you know, so it's not reaching up to the Department of Labor level the majority of the time, I would say.
I think we need a new information system.
Well,
Yeah.
yeah, and I've urged the department to think about other ways to educate unrepresented people about these penalties and to get the word out because it is happening quite a lot.
The aggrieved party had to hire a lawyer,
Right,
which
It's
depending
expensive.
on your wage level
yeah.
is not possible.
Well, I work on a contingency fee,
Basis, okay.
meaning down the road, but it is frustrating sometimes to see folks who feel like they have to hire an attorney because of something like that, you know?
Yeah.
I usually identify other ways I can help them in the claim, because I'm not gonna just represent somebody only on that issue. I would certainly be urging them, get in touch with the department if that's the only issue in your claim. But yeah, I can't say there's carriers who are notoriously always late, but there's definitely claims that it's happening, certain adjusters that it's happening. And to Jamie's point that, you know, folks are waiting for a check stub and that's why it might happen. It's not a late payment if you don't have the check stub yet to calculate it. When you have that temporary partial and you're handing in the check stub, and that's what we're talking about, how many days you get to actually issue the payment, what's the number, 3 or 7, the clock doesn't even start counting to be late until you have, you know, the information and there's some deadline attached. So what I often see is the person fell off of auto pay, which is just, I think that the adjuster is putting in, pay them for 3 months. And then the 3 months comes up and they just haven't looked at the file again to institute more payments.
So how do you, so the adjuster is an employee of the insurance company?
Or an agent, yes.
Or an agent. So it is under your umbrella of concern if an adjuster is the problem. And so it strikes me that in addition to DOL, you need instant you need similar communication with the insurance industry, maybe with Jamie, who's representing them.
And you know, we certainly will contact supervisors, you know, when things are repeatedly delayed, absolutely.
Okay.
Yeah.
Anything
I
else?
think that's, let me just double check, sorry. My chicken scratch here. I believe that's everything. And I agree with the point, if it's not a problem, what's the objection to having the increase in penalties?
So you agree, but you see the problem as on the ground.
Absolutely.
Okay.
Absolutely, and I feel like it's gotta hurt a little bit more for it to stop, you know, or for it to not happen as often as it's happening. Oh, just while I was sitting here, I got an email from my paralegal because one of my clients didn't get her direct deposit yesterday. And it was because one insurance carrier accidentally issued all paper checks instead of the direct deposit that she was, and I'm trying to figure out, and I was going to draft an email to Mr. Anderson about, is this happening with all of that carrier's claimants this week? Because that seemed to be the message my paralegal got. Oops, they all went out as paper checks this week. So somebody who was planning on a direct deposit on Wednesday isn't going to see their check now until Monday. And I'm not sure, but that could have been a carrier-wide problem this week for that particular carrier. It's just about getting injured folks who are already got a lot of obstacles and difficulties and struggles. It's just trying to make sure they're getting their wage replacement benefits on time.
Right. Yeah, and to that point, it is, we expect to be paid, or people who are working expect to be either paid weekly or bi-weekly, and it becomes an increasing challenge for people who aren't
Yeah.
getting
Yep.
their income. Okay,
Thank you so
thanks.
much.
And anything you could submit, both of you, in writing to Scott would be helpful, if that's possible. I think, Dirk, we're pretty clear, but it would be helpful, I think, for Jamie and Kelly, if you can do that. And thank you.
so
We will
much.
take this up again and finish the UI pieces, which I, at another point, but I think with Kelly and Jamie in the room, it's great. And Ken, we're going to get you back.
Yeah, it's really.
So we are going to have a break until 11:15, when we are going to take up
20 minutes.
yeah.